In a recent landmark ruling, Alabama's legal landscape has undergone a seismic shift, sparking debates and discussions across the nation. At the heart of this ruling lies a deeply personal realm of reproductive rights and assisted reproductive technologies. Here to shed light on the legal, ethical, and medical dimensions at play is Dr. Jeris Cox, medical director and owner of Adore Fertility. Dr. Cox, thank you so much for joining us today.
Absolutely. Thank you for the opportunity.
So before we get into this, we have to talk about the situation that led up to this ruling. Can you talk about that?
Yeah, so essentially there were 3 parents couples who had underwent IVF in Alabama. And some of them had success stories of prior children, but ultimately had embryos frozen or cryopreserved is what we use the language in the IVF industry, for a potential use for future children. Okay. And what happened is that a wandering patient got behind doors that should have been restricted and closed down, and this patient opened tanks and got burned because the tanks are below 0 temperatures in liquid nitrogen, and they dropped canisters that these embryos were in and destroyed these patients' embryos. So ultimately, these patients went to seek punitive damages in a civil court for their losses. And under Alabama's Constitution and their common laws, when they went through the trial courts, they attempted to do a claim such as a wrongful death of a minor act, which is part of Alabama's Constitution. And the trial courts knocked it down, saying that they did not have rights to use that act or any of the common laws in Alabama to in fact seek damages for their losses. So this is how it got appealed up to the Supreme Court in the state of Alabama.
Okay, so are frozen embryos typically looked at in a form of property, or is it looked at as a person?
Great question. So this is something that really legislation and our society have really not defined. And I think that's why this is a bigger picture, is that there's lots of definitions of how you look at an embryo versus a child, intrauterine, extrauterine. And so there's a lot of confusion, and I don't think there's necessarily a right or wrong. It's just about educating us and seeing how far we've advanced in society, and maybe our antiquated laws don't actually conform to what we're doing now, you know, as an industry.
And for those who may not know, Dr. Cox, can you kind of say what the Alabama ruling was?
Yeah, so ultimately the Supreme Court's job in any state, I mean, they have many different duties, but one is to look at appeals that have come through the trial courts to see, did the judges prior to them read the language of the law that they have currently in a correct way. And ultimately, the state of Alabama and the Supreme Court felt that in the wrongful death act of a minor, essentially it was created in 1872, so long time ago when these laws first came into play, right? There was no IVF going on in the 1800s, and stated that couples could actually go after punitive damages for a loss of a child if that death occurred because of omission, negligence, or harm. And then in 2011, another precedented case came up in Alabama stating, well, what about unborn children? What if unborn children were killed unlawfully or something from negligence? And it wrote into that law that yes, unborn children should also be able to be held under this law as well. And in another case came to the fact that any stage of viability of an unborn child should also be able to hold under that act. And so that's how it came to the Supreme Court. And the Supreme Court looked at the writing and said, listen, we realize there's some very difficult decisions that this case is bringing up, but in the end of the day, what they have written in their Constitution and the precedent cases before this case specifically said born or unborn without limitation. That was the reading in their Constitution. And so they said because of that, because it says without limitation, there's no written scripture that says if it's an extrauterine child or potential child that it can't be included under that.
I'm sure that there are some healthcare providers in Alabama that are maybe putting a pause on their services. How is this directly affecting patients currently going through IVF in Alabama?
Yeah, so currently it's not really affecting their treatment. Certainly it's causing fear, right? Because there's some unknowns that are coming from this down the line. But from my understanding, most of the clinics are operating, still doing IVF. The only thing that they're pausing on is discarding of embryos, which is what this case has brought to light. Can we discard embryos, or are we letting ourselves open for liability in a civil situation in Alabama?
Yeah, and now this is just Alabama alone, but how will this ruling possibly affect discussions regarding fertility treatments and family planning services in the Lowcountry in South Carolina?
Yeah, I think that I look at this case as a positive in the sense that it's bringing to light a lot of questions that we have surrounding our industry and the regulations in our industry. Obviously, whether you believe the definition of a child, which widely ranges.
Yeah.
But the scary thing, and I think rightfully so too, is that the what ifs.
Yeah.
Could this extend past just saying, okay, someone has a right to sue me because we damaged embryos, or does it go further to say that now these patients that go through IVF and have embryos created have no right to discard them, because then what do we do with these embryos? Yeah. And therefore there could be a lot of ramifications down the line that could change IVF, limiting us to how many embryos we create. Thus, costs could go up, and those are the concerns that the Alabama clinics and hospitals have currently, is how is it going to affect the cost and the patient treatment and access to care?
Absolutely, understandably. So, Dr. Cox, thank you so much for joining us, and hope to have you back when, as this story progresses.
Absolutely.
We're back in 2 minutes.